We are really happy that you've taken the time out of your evening to join us tonight. I'm Beth Cohen-Dorfman, Programming Director for NPN. Before we begin, just a few things to keep in mind. We at NPN value your anonymity and the delicate nature of this topic. As you post questions, know that you can post them either publicly or send them privately by unchecking the To Everybody button at the bottom of the chat screen just to the webinar administrative team. This team consists of myself, Colleen, our webmaster, and Jennifer Quigley, who's leading the talk. Ms. Quigley will present for about 45 minutes. Feel free to comment and ask questions the entire time in the chat box. Please make sure to keep your questions very general. If they do not apply to most people, she will not be able to answer them. I'll keep a log of the questions, and she'll answer them in the last 15 or so minutes of our time together. Also, this webinar will be posted to YouTube. You will be sent an email link to that post along with a very short survey regarding your experience tonight. Please take a moment to fill out that survey so we can continue to improve our new webinar series and bring you pertinent information. We are thrilled to have Jennifer Quigley presenting tonight. We know that she will cover this personal topic with compassion and professionalism. Jennifer is in her 7th year of practice as a Chicago attorney, focusing a large portion of her practice on family law. She has been an NPN member since 2010, and she and her husband live in the Logan Square neighborhood with their 3-year-old daughter. She also currently serves as the president of NPN's board of directors. Without further ado, here she is.
Hi, everyone. Thanks so much for joining us tonight for this webinar. I hope that you'll find the information relevant and of interest to you as we kind of discuss just some general topics of divorce and separation in Illinois. So Beth already kind of went over a few items in terms of disclaimers, but I do have a few more that I just want to mention before we get started. So this webinar will contain some general information on divorce and separation in Illinois. The information provided does not form an attorney-client relationship, and the information is general in nature and should no way be used as a substitute for seeking the advice of your own attorney. This webinar also contains information specific to Illinois law. Participants should be aware that local court rules in different counties, even throughout the state of Illinois, can vary. So again, it's best to seek out a practitioner to pose those specific questions to, and even better if that practitioner is in the county in which you are located. Just as a side note, most of the experiences that I've had have been in Cook County, and I imagine most of you are in Cook County. So I will try and make that clear when I am talking about local court procedures to point out that that is indeed Cook County and not any other collar counties. So why this seminar? Why is this a good idea? Well, you know, the process of divorce is one of the most stressful events of a person's life. For some people, it's the absolute most stressful thing they'll ever go through. I find that really arming yourself with as much knowledge as possible will help to alleviate some of that stress. Because a large part, at least from my own clients, a large part of the stress that they are experiencing is from the unknown. And I hear it a lot, you know, well, what should I expect? You know, what's going to happen next? You know, give me an idea of what's happening. And with that knowledge, it always seems to help a little bit to get that, you know, next step and knowledge of what's going to be the next thing that's going to come down the line. So that's the goal of this webinar, to arm you with some information so you can feel just a little more comfortable with the process and what to expect. And of course, only your specific attorney can give you that roadmap that is going to be applicable to your actual case and circumstances. So the first thing we're going to kind of look at is the legal process involved in a divorce. So essentially, your divorce case is going to start with something called a petition for dissolution of marriage, and this is something that's filed by the petitioner, and that's going to start the divorce case. Once the petition for dissolution is filed, then something called a summons for service will be issued, and in some cases the petitioner will have that summons served to you, and sometimes the attorney for the petitioner will just, you know, send that summons to you and ask for you to file your appearance without having the discomfort of being served at home or at work. But those kind of two steps are what starts the case. And then where it goes from there really depends on what type of case it is, which I will be discussing shortly. And in fact, some cases are actually fully settled by the time it even gets to to the step of filing the petition for dissolution of marriage. So it depends on your particular case, whether that whether that's the start of your case, or in some circumstances the filing of the petition is actually the end of the case, where it's going to be proven up very quickly because all the details have already been worked out. During the process, you are going to be encountering many professionals. And again, it's dependent on your case and the particulars of your case, but the professionals I have listed here are some of the key players that you can expect. Attorneys, that's pretty self-explanatory. The parties that are going through the dissolution may well be represented by attorneys. Sometimes, though, one or both sides may not be, and they may choose to go forward pro se and represent themselves. But there's usually at least one attorney on one side of the case. The next professional that is going to be typically encountered during the process, either at the beginning or during, are therapists. And therapists play a super important role here, and I can't really stress enough how important that they are in the process. It's really, really important that you and your children ensure that you have a very strong support network throughout the process. So part of that is enlisting help of therapists who have specifically experience with divorce and separation. So litigation is stressful as enough, but divorce litigation is especially stressful because the stakes are so high. I mean, we're talking about your kids and your finances, and those two things are of utmost importance. And so I really always caution my clients to be really gentle with themselves and seek as much positive support as possible for themselves and for their children. There's several different types of counseling and therapy that parties can kind of enlist during the process. You can go through family therapy, which is obviously everyone together, meeting with the therapist. You can do individual therapy, where that's just the party themselves going. Co-parenting therapy or counseling is where just the parents are going and they're learning to kind of get into this new role of being co-parents but no longer a married couple, and getting help through the process of how they can do that as easily as possible. And then of course children can also be really great candidates for some therapy throughout this process. So when is a good time to seek therapy for your children? One of NPN's business members, Denise Duval-Solis of Child Therapy Chicago, gave me a really great list of some behaviors that are good indicators that a child going through this process might benefit from some additional support. Things such as changing in sleeping or eating patterns, a regression in their behavior, for example, toileting accidents, clinginess, baby talk, more frequent and or severe tantrums or meltdowns, if they become harder to calm or soothe, if there's trouble with transitions, from mom's house to dad's house, anger, aggression, compulsive behaviors, disobedience, talking back, difficulty concentrating, problems in school, problems with peers, loss of interest in activities, withdrawing behavior, excessive caregiving and compliance. So, for example, taking on a parenting role or intervening as a mediator between the parents, or showing no signs of stress at all, acting completely happy and that everything's fine and normal. So these are a list of things, that could be an indicator that the child is having some issues and it's starting to affect them more than just, kind of typical separation anxiety. So these things might be, indicative of the need to enlist the help of a professional. The next category of professionals that could be encountered during this process are GALs, child representatives, and attorneys for the child. And I'll go through each of these in turn. But these are essentially professionals, and they're typically attorneys that are assisting in the case itself. So a GAL is a guardian ad litem, and this is usually an attorney. This person is appointed by the court to investigate the circumstances of the case and interview all of the parties involved, including potentially teachers, therapists, other people who are communicating and dealing with the children frequently. and then to submit a report to the court. And that report will give the recommendations of the guardian ad litem as to what is in the best interest of the child. So that is kind of, you know, they're the eyes and ears of the court. They're court appointed, and they will then be made to testify in court on their findings, and they can be cross-examined. And they're appointed, and they are not on either of the parties' sides. They're actually looking out the eyes and ears of the court in that role. A similar but certainly distinctive role is a child representative. So in a case where custody or visitation is in dispute, just as with the GAL, all of these professionals, they're only really appointed if we're disputing custody or custody or visitation. The child rep, again, is kind of tasked with investigating, you know, the facts and circumstances of the case. They're not going to testify, though. The information they glean from the child is confidential, so they aren't made to testify on those conversations. They do make a recommendation as to what he or she feels is in the best interest of the child, and that recommendation is typically made at a pretrial conference. And really, the child representative is an advocate for the child and the child's best interest. The child rep can participate in the litigation, but it's different from the GAL because the GAL is more the eyes and the ears of the court, not necessarily advocating for the child in one way or the other. And the GAL can be made to testify. The child rep can't. The GAL can disclose all things that the child tells the GAL. The child rep can't. And there's different analysis and different reasons why the GAL is appointed over the child rep or vice versa. But just good to know that these are, you know, some of the professionals that could be encountered in the process. And you know, it really is dependent on the county. I mean, in Cook County, we have a lot of child reps that are appointed as opposed to GALs. It seems like it's more, you see it more, the child reps more prominently being appointed. That's just, you know, it could very well just be a county thing, because I know that in other counties it's the opposite. GALs are more likely to be appointed than a child rep. The last category is attorney for the child. An attorney for the child is just what it sounds like. This person advocates for the child, what the child wants. There's total and complete confidentiality. They can't be made to testify as to communications, you know, with the child, and they're simply advocating for what that child wants. So those are the three categories of attorneys that may become involved in your case that are outside of the parties' attorneys. The next category is mental health professionals. So this is typically a psychiatrist or psychologist. In a custody case, these mental health professionals may be called upon to conduct a mental evaluation of the parties and then to testify as to the recommendation on the issue of custody or other pending custody-related issue. Typically, it is when the mental health of either the parties or the child is at issue that one of these mental health professionals are appointed. Now, the court may appoint this expert, which then becomes the court's witness and neither party's witness. Or an individual party may hire their own mental health expert and present that report or testimony as evidence in their case. So, you know, it's essentially one other layer of another professional that can give some opinion as to custody or visitation, because the court really needs that assistance if this goes to a full custody trial. It can't just be a he said, she said with the parties. They're going to look for an outside party, either the GAL, the child rep, the attorney for the child, and then additionally maybe also one of these mental health professionals if there are those issues present. Another category of professionals you might see are expert witnesses, and it really all depends on the complexity of your matter. You may need some expert witnesses to testify on your behalf, and that person will need to be involved in the matter as early on as possible. And those potential experts could be vocational experts. They're most likely to be used in maintenance cases, perhaps when we're trying to, you know, put on evidence about the employability of a spouse. CPAs, those are experts who can come in and testify as to the tax ramifications of certain distributions of property. Real estate appraisers, they can come in and obviously they can give, their expert opinion on the value of the property, real estate property in the case, financial professionals. All of these are, potential expert witnesses that you may or may not need, but, that just another category of who you may encounter. And lastly, of course, judges. Judges are the person who is going to decide your case if it goes to trial. If it goes all the way to trial, then they will be able to decide the issues, any and all issues that are before him or her, and that's primarily custody, visitation, and the financial distribution of assets, the allocation of debts, and whether or not either party is going to be getting maintenance, as well as the issues of child support. Some issues can be decided and settled, and maybe you just go to trial on remaining issues. But a lot of people ask if they've gotten halfway into the case and the judges are not ruling in their favor, can we have a change of judge? And the answer to that is no. Once you're in a case and you've had a judge make a substantive ruling on your matter, there's no way to, transfer to another judge unless there's some sort of, legitimate reason such as bias. Everybody does get one change of judge as a matter of right, but that has to happen before any rulings have been made in the case. So one thing that's it's good to know when going into this process and thinking about how it's going to work and how your particular case is going to flow is the opportunity to do some alternate dispute resolution. So for couples who elect to conduct the process outside of court as much as possible, ADR typically comes in the form of mediation or collaborative law in divorce cases. The goal of both mediation and collaborative law is to promote the resolution of all the issues between the parties through voluntary, confidential, transparent, and informed negotiations between the parties with assistance from various professionals. There are several methods to consider. Again, the two main ones are mediation and collaborative law. So mediation, this is a process where a single neutral mediator meets with both parties to go through all of the issues. The attorneys for the parties can be present here, but typically they're not. It can be a day of a session, or it can be several days, maybe weeks, where the parties are going and meeting with this mediator to try and get all of their issues resolved. It just depends on your mediator and I guess the complexity of the issues and whether or not the parties really do have a good faith vested interest in trying to work it out and know that going into it you're going to have to concede. If the parties go in and they think that they're just going to stand their ground and not budge on anything, then mediation is absolutely not going to work. Mediation is really in terms of cost, and I will get to that, it's very cost effective. It's a great resolution for couples who really have a vested interest in staying out of court. They don't want to spend a ton of money on litigation or drawn out proceedings, and they are able to kind of civilly work through these issues. Mediation is a great fit in that circumstance. Mediation can also be used throughout the case. So, some couples will go initially before they even hire attorneys, or maybe they've just hired an attorney but they haven't filed the case yet, and they'll go to mediation, try and work everything out and get an agreement in place before anything's even filed. But sometimes it works differently, and the case is filed and you get into litigation, and then the parties decide, look, let's try and work through these issues that we are clearly not getting through in litigation. So they can stop kind of midstream, go and mediate. They can mediate the financial issues or the custody or child-related issues. And in fact, in Cook County, there is mandatory required mediation if there are any visitation or custody issues present at all. So it's not even optional in that matter. It has to be done. And when thinking about mediation, you want to decide who's going to mediate for you and who may act as a mediator. Well, essentially anyone can call themselves a mediator without any real particular credentials. Many circuit courts will have a list of court-approved mediators. So these are people that are experienced and they, have worked on matters and, can kind of be vouched for. The Mediation Council of Illinois is another resource for finding qualified mediators. I personally, I have had cases where I've had mediation agreements come to me from a non-attorney mediator and then from an attorney mediator. I will say that the ones that come from the attorney mediator are more grounded in Illinois law and what the parties would likely get in a actual judgment that's gotten through a trial. I think one of the issues if you have a mediator who's not an attorney is they don't know the ins and outs of the law. So they don't know in depth what those parties would get if this case did go to trial. So what happens is if you get a mediated agreement with that non-attorney mediator, but then it gets in the hands of the reviewing attorney for the party, then things can fall apart because the reviewing attorney will look at it and say, this is so unconscionable, so unfair, given the law and given what you would likely get if this were to go to trial, that it would not be prudent to agree to these terms or this particular term, what have you. So I personally think it's more productive for the parties to go to a mediator who's also an attorney, just so that there's that background and that legal knowledge to know what this case might look like if it did go to trial and what could potentially the outcome be. And so then it looks to be a more fair and equitable agreement. And quite frankly, judges won't always approve a settlement agreement unless the judge feels that it's not one-sided, it's not unconscionable, there hasn't been some strong-arming going on. They will not always approve settlement agreements as a matter of course. They will look to that agreement to make sure that it comports to fairness and the law. So it's good to have an agreement, of course, but it needs to be fair and it needs to kind of fall in line with what the law would allow. Collaborative law. What's collaborative law? That's a process where each party has an attorney, but they agree to stay out of court, and they work together with the other side and other professionals in a cooperative manner to resolve the issues. The process will typically involve, a financial professional or a CPA, a child specialist professional who can weigh in on any child-related issues, and the process can, it can be anywhere from maybe a few weeks to a few months, maybe up to a year. Typically, it's not as long as full-blown litigation, but it all depends. It all depends on the case and the complexity. One key component of collaborative law is that if the negotiations fall apart, the agreement that the parties sign say that they may not use the same attorney to proceed with litigation. So that's usually, a factor that the parties will take into account. If it falls apart and they're not able to get to that agreement through the collaborative law process, then they have to switch attorneys and get a brand new attorney, and they've been working with this one for however long it has been, put time, invested money. So, I think it's just one of those rules that kind of helps to, ensure, at least give the best chance possible that the parties are really vested in getting this case done this way, because the ramifications are you got to start over from square one if it falls apart. So part of the process of separation or divorce and kind of looking at those next steps is you're going to have to interview and select an attorney. Divorce attorneys are really different than some of their civil counterparts, like personal injury attorneys, criminal defense attorneys, those types of attorneys. There's typically no winners or losers in divorce. So if you ask, the attorney, well, how many wins have you gotten? It's not the same. A lot of divorce is just, conceding, and neither party usually walks away feeling like a winner. And that's just the nature of it. So if you're looking at interviewing an attorney, you're not going to ask them the standard questions like perhaps you would ask a personal injury attorney. I think, a good thing to ask is perhaps, their approach and how do they do they like to approach cases aggressively? Do they like to approach cases sort of collaboratively and with a mind and, with the goal in mind of settling and trying to come to a consensus? What is their attitude towards the case, and how do they approach things? Perfectly acceptable to ask any of the following questions. How many divorces have you taken all the way to judgment, meaning all the way to trial? Do you represent one or the other of a spouse more often? So, if it's someone that's always representing, the father, and that's their, focus, and they do that, 90% of the time, may not particularly be good for, the mom to and wife to use that attorney necessarily. Not a hard and fast rule, but it's a good question to ask. You should know if they do have more of a focused, I won't say specialty because attorneys can't say that they specialize in anything, but certainly attorneys do tend to sometimes focus in one area. So you want to just know, do they have a focus? And maybe the answer is no. They've worked on both sides, and they're well versed in representing both sides. I think that another good question that you would want to ask is, think about your particular case and your particular circumstances, and look and see if there's anything that you think is really important, that's unique or special about your case. And then ask the attorney, have you worked on a case with fill in the blank, a special needs child, a spouse that lives out of the country, a multi-million-dollar marital estate, where there's been domestic violence involved. These kinds of things are things that you're going to want someone who's done that kind of work before. You don't want someone who's not ever dealt with that particular complex issue to just be kind of doing it for the first time with your case. So it's something that it's a good question. And then, of course, what are your rates, and what are the rates of the people who are going to be working on this file? Because in some law offices there will be, partners, there will be their associates, the paralegals, the law clerks, and the secretaries. And all of them will have different billing rates, and all of them may or may not be working on your case at any given time. So you just want to ask and know what those rates are, and have that in mind when making your decision as well. So what about the other side of things? What will your attorney be expecting from you during the process? A lot of times, it's not a big list, but I think one thing that's huge, that's really a priority, is reasonable responses to requests for information and discovery. So when things are propounded onto you as a party, discovery items, maybe you have to be deposed. These things are usually time sensitive, and there's usually a potential for sanctions if you're not complying with these things in a reasonable amount of time, or the amount of time that is required by statute. So, not that there can't be any exceptions to that rule, but, if you're just kind of like don't feel like dealing with the divorce, and you just want to kind of hide in a hole and not be present, it's not going to behoove you. It's not going to be good for your case. So certainly good communications and reasonable responses to information is going to absolutely help you in the case. Attendance at any court hearings, pretrials, or other court dates where the judge has ordered the parties to appear. Court hearings are kind of self-explanatory. Pretrials, a pretrial is just a situation where you're probably done with discovery, and you've got some issues that have not been resolved through negotiations, and you want to get an idea of what the judge would rule on those issues if the case were to go to trial. So both sides put on their case. They let the judge know what the evidence would be if it went to trial, what they would put on as evidence in this particular matter, and they ask the judge to give them a ruling on that as if that issue was before them. And so the judge will do that, and then will give a ruling, and it won't be an official ruling. It's just a recommendation, so that hopefully the parties will take that recommendation and go back and settle based on what the judge has recommended. And this does get settlement in a lot of cases, because the thing is with many of these cases, the same judge who has been hearing all of the pretrials and all the hearings and seeing all the litigation, they're going to be the ones to do the final trial. So So if you've got a judge who's giving you an opinion on an issue and you're not in dispute about the discovery and all the evidence that's being presented, then their opinion likely won't change much at the trial. So a lot of parties will, look at that pretrial recommendation very, very hard and very seriously before proceeding on to trial. Another thing that the attorney is going to expect from you is being completely forthcoming with information, whether it's good and whether it's bad. I mean, there's, the ways that you can present things in a different light that will not be as bad as what you think it may be. It's better so that your attorney knows every facet and every fact so that they can help you in the best way possible. And the worst thing is if you don't tell your attorney all the important facts and then it comes out either at a hearing or at a trial and your attorney's not, able to, adequately defend you in whatever manner that is because they never knew that particular fact or information. And then to also relay that information to them in a timely manner. So if something happens that you would deem important, you'd want to just let your attorney know when that happens, not 6-8 months down the road, because again, these things can come up and you don't want to be surprised by them. I think the last thing that I see that is a good expectation is healthy boundaries between you and your attorney. And just an appreciation for the attorney's time and the amount that's billed for each, phone call and email. Sometimes I will tell my clients, look, it's going to be more cost efficient if you want to send me emails during the day and kind of consolidate everything in one, for that day, rather than send me like 10 different emails on that day that I have to read and respond to. And certainly sometimes emails can be quicker to respond to and easier than a phone call. And so I like to kind of give my clients those kind of tips. But, sometimes also the client will call and it won't really be much about the case and the technical aspects of the case, but kind of just wanting to vent, which is fine to some extent. But, I think sometimes it gets to just a level where it's clear that that person really does need someone to talk to. And I, as the attorney, I'm not well versed in, the therapeutic kind of, whatever, those kinds of things. I'm a technical person. I'm, and I'm looking out for legal aspects of your case, and it's just one of those things that I will tell the client, hey, have you thought about talking to someone? And, I know there's a lot of emotion that's kind of hard to handle during the process. So that's, just know that your attorney is there for you. Absolutely should listen to you, but certainly is not a replacement for a good counselor or therapist that can really give you the tools that you need to get through the process emotionally. Now, what should you expect once you've hired your attorney? Absolutely a written retainer agreement. It should outline the scope of the representation. So it should say every single thing that's going to happen and what that attorney is going to do for you during this representation. Are they just handling your divorce? Are they agreeing to handle your divorce plus any pre-decree issues that come up, plus any appeals that need to be filed? Or, are they just doing perhaps a prenuptial agreement and nothing outside of that? They should be saying exactly what they're going to be doing for you in that retainer agreement. They should also be at a minimum including their and their staff's rates, what activities they're going to be doing that are billable, how the costs are to be paid to them. Is there a retainer that's taken and then billed against? Is there just a monthly invoice that's sent every month? What happens when the retainer is depleted? Do they want a full retainer payment to replace it and replenish it, or can you just go on a monthly basis from there? Get all of these details in writing, because you just don't want to be in the circumstance of not not being able to manage the financial aspect of the case, and know what's expected from the attorney on the billings. Something called a statement of client's rights should be attached, which is appended to every retainer agreement and family law cases in Illinois, and that just tells you what your rights are in terms of the attorney-client relationship. You should expect frequent contact and forwarding of all communications, pleadings, discovery. You should expect consent before entering into any agreed orders or settlements. You should expect thorough explanations of all potential courses of action, both orally and in writing. You should expect them to be accessible, within reason, of course, but accessible to you for questions, answers, and just, you know, to touch base and give a status within reasonable time periods. You should be a good listener. You shouldn't feel like you're being rushed through meetings. You shouldn't feel like you're not being heard. If you're saying something over and over and over and nothing's being done, perhaps they're not really listening to you. You want someone that's going to sit and really pay attention to what your goals and objectives are and advocate based on those. A good rapport in the sense that your case is a priority. You should never hear from an attorney that, you know, they've been busy with other files and that they're so sorry that they haven't gotten back to you. That's, you know, that you should always be a priority, you know, in terms of your case. And, you know, all attorneys have to act with due diligence on all their matters that they're currently handling, and if they have, you know, too much on their plate, then they should let you know that. But absolutely, you should be a priority and feel like a priority. So financial considerations is our next topic, and there's a lot of financial considerations that you want to think about when going through this process. So the first one I have here listed is maintaining status quo. So when a case is filed, there is something called an automatic stay that's put into place, which basically says that neither party will transfer assets, will move money from accounts to accounts, will drain accounts, will dissipate marital assets. Everything should just remain status quo, meaning the last peaceable status. So if you're paying rent, if you're paying your car payment, if you're paying, you know, your normal operating expenses and bills, that's fine. But there should not be any, you know, transfers of money, big major withdrawals out of accounts without that other spouse's express consent. Payment of attorney's fees and costs is another huge financial consideration. There's something called the level the playing field rule of law, where in Illinois, you know, we have one of our statutes says that there should be equal access to marital assets for the payment of attorney's fees and costs. Just because one party has most or all of the assets in their name and has the ability to write checks from those accounts solely does not mean the other party cannot have also the same level of access to that money for their attorney's fees and costs. So it's important to note that if it's a situation where there's a stay-at-home wife or husband and the other party is the sole breadwinner and all or most of the assets are in that party's name, it doesn't mean that you won't have any money for attorney's fees. It may mean that your attorney will need to go and ask for that via petition if the other spouse isn't willing to, you know, voluntarily give you some money for your fees. But that's you know, it's not fair that one spouse gets to, you know, hire the most expensive firm in town and the other spouse has not a dime to have anyone represent him or her. So it's an important thing to note that the courts want this to be as equitable and fair as possible. There is also temporary relief. So if once a case is filed, you know, a lot of times one party will move out and the other party is there at the marital residence, and perhaps that party can't afford the bills themselves. It may be a good you know, opportunity for some temporary relief, either in the form of temporary child support or temporary maintenance, basically just to kind of keep the status quo while the pendency of the case is happening, so that, you know, the house doesn't go into foreclosure and the lights don't get shut off. So there are those remedies. So it's not like you have to wait until the end of the case to get this support. It's there on a temporary basis as well. I'll back up just a second. Temporary relief can also include things such as exclusive possession of the marital residence. It's a high burden to meet, but it can be granted so that one party must leave the residence and leave the other there during the pendency of the divorce. A TRO, which is a temporary restraining order, to prevent dissipation of assets. So if you find that your spouse has been, you know, draining all the accounts and you know, you need immediate relief to ensure that that stops, and then also a freeze on those accounts, a TRO can be filed in that instance to try and stop that spouse from continued dissipation and withdrawal of assets. And actually, I just clicked past the last item on that slide, and that was maintenance and property division. That's the last you know, financial topic I'll talk about, and that's essentially the two main things that are decided in the divorce, other than the support or the child support, but the property division. So you've got your marital property. Who does it go to, and what percentages? So in terms of the property, there's a list of factors that a judge can look at. Includes such, and it's about 12 factors long, but it includes such things as the contribution of each party to the acquisition of the assets, the dissipation by the parties of those assets, the duration of the marriage, the relevant economic circumstances of each spouse when the division of properties become effective, any antenuptial or prenuptial agreements, the age, health, station, occupation, amount, and sources of income of the parties. There's a huge laundry list, and the judges can give different weight to different factors. But there's some case law that will tell us, what percentage of the marital assets will go to what spouse after a certain length of the marriage, and given other factors there. But just know that there is a list of factors that will be looked at, and it also kind of plays into the maintenance award. So the two could be worked in conjunction with each other. Perhaps there's no maintenance to one spouse, but they get more of the marital estate. They get more than half. So they're not acting in a vacuum, the property division and the maintenance. They can act together sometimes and be considered together. Now, maintenance, we just had a new change in the law as of January 1st. And so the old law for maintenance said that the judge could look at certain factors to determine if maintenance was appropriate to be awarded to one of the spouses. And then if it was, the judge could decide how long that maintenance could be paid and what amount. Now, under the new law, it says there's still those factors that have to be considered to see if a maintenance award is even appropriate. But if the judge does, if the maintenance award is appropriate, then the next analysis is there's a guideline that the statute puts forth, and that is essentially a formula for how long and what amount the maintenance should be. So we do have some more guidance in this realm. It's not so much of a unknown as it used to be, but the judge can still deviate from the guidelines. So you still have attorneys making arguments that these guidelines shouldn't apply to this case for this reason. So it's not a for sure, and there's some income caps to where these guidelines may not apply, but there is some more concrete objectivity in the awarding of maintenance. So in terms of children and going through the process, one thing that you're going to see, so once the case is started, is the maintenance of the status quo. Again, the last peaceable status between the parties. Who was the primary caretaker? Who remained in the home with the children, for the majority of the time? And is that, a safe, situation where there's no mental or physical harm being done? And then, that's going to probably be maintained during the pendency of the matter. Again, in terms of children, you could have temporary release, which could be in the form of temporary custody. Although rare, we just kind of keep it, as is, as whatever the temporary, whatever the status had been, we just kind of keep that going. But sometimes it's appropriate to get an actual temporary custody order, and also temporary child support, so you can, be able to support that child if you are the primary caregiver. So when there are contested issues, that's when the mediation parenting course will come into play. Again, we had talked about the child rep gal, the attorney for the child appointed, and the evaluation by a mental health professional. These could be present. Any one of these will definitely the mediation, but then also the appointment of the other professional in a contested custody or visitation case. Timeline and fees. So uncontested divorces are typically the quickest and cheapest way to go. So you come to the attorney. Perhaps there's two attorneys, maybe there's one, although the one will only represent one of the parties, not both, and you say, we've got everything agreed to, we just need you to make it official. We need you to put it into a marital settlement agreement and or a joint parenting agreement or custody agreement, and do whatever needs to be done to get this thing entered as a judgment. So that's the true sense of an uncontested divorce, and the fees can range, but that's it. It's typically the cheapest and shortest amount of time in terms of, from start to finish. The divorce using ADR, it can all depend. Mediation is typically cheaper than the collaborative law process because in the collaborative law, you're paying all those professionals and the attorneys for every session, and there's usually several sessions. But the timeline can be varied. It's typically, though, with ADR, you're not usually spending as much time as in litigation. And again, it really depends. And it also depends on the complexity of the matter. I mean, if you have a ton of complex tax and financial issues and there's business interests that need to be, valued and interest in those businesses and worked out, you're going to have, a much different case than perhaps if there's just, some standard assets like a house and a pension. The contested divorce is by far typically the most expensive and the longest. As compared to the other two types of divorces. So I see we're about 9:20, and I know we're supposed to finish up at 9:30. So I am going to, and I know there's probably some questions, so I'm going to get through this next slide fairly quickly. So this is just some resources that I've kind of put together that I've seen be really helpful to a lot of my clients. I've seen this list kind of be, recommended to by other colleagues, and so it's just some organizations here in Chicago that deal with helping individuals get through the process in one way or the other. And I'll just kind of put these up here. And I know that this presentation will also be available via YouTube, so if you want to get the list, it will be available that way too. And I can also email the slideshow. If I can give that to Beth. So if people want the slideshow, I'm happy to do that. So you can get, have this list all together. So I'll just kind of move to the next item, which is NPN business members as resources. We have a pretty extensive, NPN has a pretty extensive list of business members that are certainly, these professionals I've mentioned earlier that can assist through this process. And on the parent perks pages, which I highlighted here in your account, you're just going to go to perks, and it brings up all the businesses with perks. You'll find that a lot of them give discounts off of the initial consultations or, off a session. I've seen there's free workshops. There's all kinds of different therapists that you can find there, and I think I saw about 7 or 8. So it's a great place to look if you're kind of doing that, if you're in the market and you're looking for that professional. I also saw there's several financial planners, Country Financial's on there, Luzader and Associates, Reinhardt Financial Group. A lot of those, or a couple of those, 2 of those, Country Financial and Luzader, they do a free portfolio review, or free financial review. It's really important in the divorce process because what you used to have as your portfolio is now completely different, and you still want to meet your retirement goals and the other goals you have established. So it's important to kind of get a fresh look at those. And it's also good to have them look at it while you're going through the divorce, because they may have some recommendations on whether you should take a bigger chunk of the IRA account or get cash instead, or real estate in lieu of. So it can be helpful throughout the process as well. There's also I saw that there was New City Moving. They're in the perks section too. So movers, and they offer discount. So it's great. I mean, it's just a starting point. The other place I've seen recommendations is on the NPM discussion forum. A lot of people have made their recommendations as to, these different professionals that they've used in these capacities, and it's a great place, also to get that support that we were talking about earlier, just to kind of vent. So, don't hesitate to use any resources that you have available to you through NPN to assist you in this process. And here I just have a quote, new beginnings are often disguised as painful endings. I think it's well suited to the divorce process. It certainly is probably one of the most emotional times that you'll experience, as well as your children. But there is a light at the end of the tunnel. And getting through it, it doesn't feel like it at the time, but it certainly can lead to some really great next chapters. So, it's something good to try and keep in mind throughout the process. And there's my information too if there's any questions. Okay, so it looks like there were some email questions, and I'm going to go ahead and get into those right now. I know we have about 6 minutes left, so I definitely want to get to those. So let me log into my email and check those, and then we can go through those. All right. Okay. Okay. Do you have ballpark figures of cost of uncontested and mediated divorce? The mediated divorce is a tricky one because it depends on how many sessions you're having and who's your mediator. I know a great mediator downtown. She's not an attorney, but she's, I mean, she charges, I think it's like $300 or $400 an hour. I know another, mediator who, I think he's around $150 an hour, and then most attorneys are in the range of $200 to $300 an hour. So, it just really depends on your mediator, what their fees are, and how complex the issues are, so how long you're going to have to be with them. So I guess I don't really have a ballpark on the mediation. It's just so fact specific. The uncontested, you should probably expect it to be somewhere in the range of $1,500 to $2,500, somewhere in there. It's dependent on whether there's children. If there's children, you're going to need a custody agreement plus your marital settlement agreement. So there's 2 agreements to draft. The attorney will have to draft. There's filing fees of about $337 for the petitioner, $203 for the respondent's appearance. So that's $500 in just court costs. So, a full flat fee of somewhere in the range of $1,500 to $2,500 is pretty reasonable for Chicago on the uncontested divorce. And that's including the filing fees and those hard costs. What about a 604B? This is when you were talking about GAL, child reps, etc. Okay, so a 604B is definitely one of those mental health experts that I talked about. That's exactly what that is. So, the 604B is the one that's appointed by the court, and the court says, look, we need some help with this custody issue. We're going to appoint a psychologist, psychiatrist, a mental health professional, and that person is going to then essentially do evaluations of the parties, the children, and then make recommendations based on their knowledge of the mental, those mental health factors. And then the next the follow-up question is, what happens when a child is an infant under 1 at such a young age? I would like the baby with me, and being fair to the father, with knowing more time will be with the father as the child gets older. There's something that used to be more prevalent called the tender years doctrine, where it was assumed that the child would be primarily with mom as an infant. That doctrine is slowly eroding. With the advent of pumping and being able to give dad the ability to feed that child outside of, being with mom, and, fathers, generally I think wanting to be more involved, it's not a given that an infant is going to be given, the most time with mom. I'm not saying that that's not a likely scenario, but certainly if you've had an involved dad, and I think this makes a big difference, if you've had an involved dad from day one, he does the changing, he does the feedings, he gets up at night, he does the bathing, he's super involved, and mom hasn't been primary, they've both been equal parties, the dad's going to get a lot of time with that infant, likely. So, it really depends on the facts and circumstances of the exact case and the comfort level of dad and how involved he's been. But if he has, then, a lot of judges see that as, we're going to continue with that. There's no reason why he can't. If mom's breastfeeding, she can pump for those times that dad has the baby. And maybe dad's not going to have the baby for prolonged overnights. Maybe it's every other weekend. Or maybe dad goes over to mom's house and visits with the child there, and kind of eases into it that way, just so that the baby has, the child has a lot of stability and consistency, because at that age it is important to have that routine. But it really just depends. on a lot of things, but in large part the prior involvement of dad. Now, when the child gets to be about 3, you know, that really the age isn't so important. If dad is, you know, been actively, you know, visiting, and you know, there really won't be any restrictions. That's at least what I've seen. There's no hard and fast rules on that. It's just kind of what I've seen in practice. And it could be different county to county. You know, I've seen that a lot in Cook, where, you know, up until the age of 3, there might be, you know, not a lot of overnights, but at age 3, that it's pretty much, you know, a standard visitation schedule every other weekend, all weekend, and at least 1 weeknight. Next question: are there guidelines for parenting time by age? That kind of goes in line with what I was talking about. There's really not. There's no statute that says here's how it should work if they're this age. It's really so fact dependent, and that's where we get these other professionals coming in, the GAL, the child rep, to weigh in on that. Or, you know, do they have an opinion, you know, as to whether the visitation is really disruptive to the child and affecting the child in a bad way, or, you know, what was happening before? Again, what was that status quo, that last peaceable status? That should be continued as long as there was no, you know, serious endangerment to the child, no mental, physical issues going on there. Does it matter who asked for the divorce, left the marriage when custody is determined? No, it does not. No, it's simply not a factor that is reviewed if custody is at issue. Are there guidelines? No, well, and I will say too, but if there was a lot of conflict in the household and a lot of it was precipitated by one party over the other, that could be a factor that's looked at in a custody matter, but certainly not who filed. If one parent moves out from the home, should they be taking the child for overnights before the divorce is finalized or even started? If they are, will this affect the final custody decision? Well, again, you know, if you have a party who's taking the child for overnights, and it's happening for a few months, and then the case is filed, and you then decide you don't want overnights to be happening, the judge is going to look at what's been happening. And if it's been overnights, then you have to show a very good reason why they shouldn't continue. So the burden would then shift to you to show why these overnights are not in the child's best interest. So again, you know, you can come up with whatever temporary visitation schedule you feel comfortable with, but if you don't feel comfortable with something and you think it, you know, even should rise to the level of supervised visitation, don't agree to that, to let that person take the child. Now, you know, there could be issues with that too, but you know, if you're consenting to it and it's happening on an ongoing basis, you're creating a status quo, and that could then absolutely have effect on what a later judgment would look like, or whether or not something is denied or granted if you go on a temporary motion for, let's say, supervised visitation, or to stop, you know, or to modify the whatever visitation schedule you have. It's just going to be a bigger hill to climb and a bigger battle. I think that is all of the questions. Let me just double check and see if I've got all the ones from Beth. I think that's all the questions that I was emailed. So with that, I would love to just thank everyone for your time. Sorry we got started a little bit late. We're just wanting to make sure we got as many people on. And, you know, again, this will be posted to YouTube, and Beth will follow up with all of that after. And please, oh, I see one more message coming in. Okay, yep, that was all the questions. So thanks so much, and take care. Have a great night.